Hi everyone, we are delighted and excited to have you here and be a part of your journey to exam success. I am Ngozi Emmanuel and I oversee all administrative aspects of the NCA Guides. Before we dive into the review proper, permit me to give a broad overview of who we are and what we do. The NCA Guides is a registered partnership of 5 seasoned and experienced tutors who we also refer to as guides. We employ a guide approach because we believe that every candidate has what it takes to successfully challenge the NCA examinations, and our part is to guide the candidate to success. We understand the difficulty that the NCA examinations present, and we help candidates overcome the obstacles and difficulties in understanding the course materials and examination formats. We do this through intensive classes, revisions, and examination review workshops. We do not believe in a one-size-fits-all approach, and our study sessions are focused on helping candidates understand the course material in a way unique and personal to them. In addition, we also offer private and intensive tutoring sessions for candidates who are in need of a direct one-on-one session. If you are interested in registering for our private tutoring session, please reach out to us via email at inquiries@ncaaguides.com. Once again, I would like to say thank you on behalf of the NCA Guides team for joining us today.
Okay, so the first things I expect you to have if you're going into the NCAs is your syllabus. And I believe everybody knows where the syllabus is gotten from. So you can go to nca.legal, go to exam schedule, exam outlines and samples. Your syllabus would be the name of the course, okay? If for anybody who doesn't have it yet. I'm hoping a lot of people on this call have their syllabus already, so it's easier to discuss and understand. Apart from that, you also need the textbook that is stated in your syllabus. And that's the Alice Woolley textbooks, the Lawyer's Ethics and Professional Regulation. Obviously, everybody has their own preference for notes. So it's good to have one of the notes that are available. They're available on different sites, available by different organizations. And also the index. So the NCA Guides has a Canadian Professional Responsibility Index that we created that also helps you in the exams. It's an expanded index of what your modal code has, and it helps you with referencing and saving time, since one of the things you should know about the NCA exams is it's a time-sensitive exam. So they know that you're all lawyers, they know that you have the information. It's now whether you can follow the steps that the NCA requires towards marking your examinations and do it in record time. So all this, even the tutoring, the free classes, this is just to help you understand how the NCA expects you to respond to the examinations and to pass it and succeed, of course. Has anyone, you can answer this question, has anyone been through the Modal code? The Modal code required for this course? Has anybody read it? Has anybody opened it? You can just say yes.
I have opened it.
You've opened it? Okay. Have you been through it? Loretta, hi.
No, just scan through it.
Okay. So one of the things I would like to advise first of all is I would say even before you go into your course content and the notes and everything, I would say try and read through your modal code at least once. I'm not saying read through and make notes or highlights, just read through so that you're aware of the information. Because from practice, we know that even though most of us are from common law jurisdictions, there's some minute and little changes between the information in our from our common law jurisdictions, the ethics there, and the ethics in Canada, okay? So it's just good to run through the model code, see what it says, the commentaries, just read through so that by the time you're going through your notes or you're going through the information in the textbook, you're aware of what the model code says, okay? So the way we're going to structure this class, we're going to run through the syllabus, look at what exactly the NCA requires you to know. And also then we go in depth into a few topics that I think are important for you to note when you're reading. I would definitely take questions as they arise. If a question is going to take quite a bit of time, I will push it to the end of the class and then we can discuss it. And then, well, end of the class and wrap up basically. So the Canadian professional responsibility is actually sectioned into 4 parts. Before I start, my name is Funto. It's spelled F-U-N-T-O. So if at any time after this class you want to send an email to me, you can reach me on funto@ncaaguides.com. So the spelling of my name, F-U-N-T-O, and then just send me an email if there are other questions or things that we didn't get to during the class, and I should be able to respond to you. Okay? There are quite a few people on the call that don't have their videos on. Can I remind everybody that there's an administrator on the call, and she's obligated to actually take people off the call if your videos aren't on. So it's something so that we can relate, or else I'd just be seeing the faces of the 9 or so people who have their videos on. I wouldn't be able to relate with you or see your face if you have an expression or understand if you have a question, okay? Perfect. So now going into... Pardon?
Sorry, this is please, I won't be able to turn on my video because I'm not wearing my right.
Okay, that's fine. Please just let us know. Okay, we just want to know that you are actually on the call, and you're there. I saw a hand raised. Edge, okay?
Yes, actually, yes, it's me. I'm trying to put on my video, but for some reason I cannot. I'm using an iPhone, and this is my first time to actually use Microsoft Meet. I've been pressing it and it wouldn't go on, so I don't know what to do.
Okay, that's okay. All right.
Yeah.
Perfect. But it's just...
I'm sorry about that. Yeah, but I'm here. I'm listening to you, and I will be able to contribute if you need me to.
Okay, fine.
Yeah, please, I'm sorry about this.
It's fine. It's fine. Okay, so let's quickly go into, we have 2 hours to go through the whole course. So let's really go into it. The Canadian professional responsibility, also referred to as ethics, is divided into 4 main sections, okay? It's actually 11 chapters. When I teach it in the intensive courses, I break it down into 13 because I think there are 2 other important aspects that we need to discuss, especially like profession and professionalism and competency. I think that's a topic that we actually focus on. So I add that to it and we discuss that in the intensive classes. But strictly based on your syllabus, there are 4 sections and there are 11 chapters. Section A, so it's divided into section A, B, C, D, okay? I know for some people you already know this, but I will run through it from start to finish for those who are learning about it for the first time or just getting exposed to it, okay? If we have time, we'll refer to the Modal code because that you have to understand. Just like there are 2 courses in the core courses of the NCA that have codes. So the criminal code and the Modal code for PR, okay? And you cannot go into the examination in PR without going in with your Modal code because they're going to refer to things in your rules. They're going to ask you questions that you have to confirm. There'll be things in the commentaries that you might not have seen or have committed to memory that you need to check. So you do need to print your Modal code when you're going to the examination. Another thing, the Modal code is unique in that it has a list of rules, ethical rules, but over time, the law has developed in such a fashion that they had to add commentaries to explain those rules to you, okay? So you might see something like Rule 3.1 or Rule 3.2, and it has maybe 20 or 15 commentaries. Some have 4 or 5, 4 or 5, 6, commentary 1, commentary 2. It's just them going ahead to explain aspects of that rule that might not be implicit in the rule, okay? There's a rule in the Modal code that states that you shouldn't have close relations with a client, and obviously from that you might just think, oh, it means I shouldn't maybe see them on a regular basis, I shouldn't go to their houses. It's only in the commentaries that you would find out that it's actually also referring to sexual relations, like a lawyer dating a client or a lawyer dating a family member of a client. So the commentaries are also very important when you're looking at your rules. There are things in there that have occurred in case law that you would find out by going through the commentaries, okay? So the first part is Section A. And Section A deals with legal profession, the lawyers in society, and the society of lawyers, okay? Section B is actually the part that deals, that's the, Benazir, did I say your name correctly?
Yeah, there's a lot of background noise. It's very, very disturbing.
Oh. Is everybody muted? Let me check. Because I'm fine over here. Okay, give me a second. Let me see if I can use an alternate source. If I mute myself, just nod. So I was muted now. Could you still hear the background noise? Okay. Oh, so it's fine now.
It's fine now.
Perfect. Okay, yeah, so we do have 4 sections, and I'm going to run through them quickly and see if we can discuss them so that we can understand. If you have a question, obviously stop me, let me know. So the first part is the legal profession, lawyers in the society and the society of lawyers, okay? The second part is the really important aspect of professional.
You're on mute.
We can't hear you.
Hi, can you hear me now? Hello? Perfect. Okay. So the first part is, I was saying that the second part of the syllabus is the content-heavy part. It talks about ethics, lawyering, and professional regulation, okay? So basically, this second part talks about your relationship as a lawyer with your client. That's where you see things like conflict of interest. That's where you see concepts like competency. That's where you see the lawyer-client relationship, and then you start discussing most of your problem questions would have instances from this section. So we have things to do with conflict of interest, confidentiality, how your relationship with your client actually is carried out, okay, and the rules that you abide by, okay? Section C talks about specific practice areas. So when you finish talking about your relationship with the client, it talks about practice areas like criminal law, arbitration, basically things that how a lawyer would act ethically in those instances, advocacy. It also talks about, so I'm still letting people in to the class. It also talks about things like the lawyer as an advocate, what is expected for him in trial, what is expected of the lawyer in, I can see your hand, Aisha. Are you calling my attention? Aisha? Okay. So it talks about ethics and the practice of criminal law, corporate counsel, required reading, lawyers and organization settings, government lawyers, things like various aspects, the ethics that are expected in those aspects of law, okay? And the final part, which is section D, talks about access to justice. The main thing you need to know about access to justice in Canada is that it's believed that there's very limited access to justice. That's a general opinion. So what do we need to do as lawyers? What is expected of us to enable the public, who we're supposed to support, who we're supposed to help, enable the public actually access justice and get the information they need, get the support they need whenever they have any issues in the society. So there's a whole discussion about that in section D, okay? So that's an overview. So we'll go through and see, I would like to touch on like specific areas. One thing I also want you to notice, if you go through your syllabus, we'll discuss this in intensive classes, your syllabus already highlights questions that the NCA expects you to have answers to. So when you're reading through, when you start your reading or you start going through the course content, you should highlight these questions in your syllabus. So for example, in section A, they already raised questions such like, what is a profession? What is public interest? What are the role of lawyers in that profession? If you do have the time after you finish reading and understanding the content, it would make a lot of sense to go through your syllabus, pick out these questions and try and come up with answers for them on your own. Now, coming up with answers for them, why is this helpful? This is helpful because, as I said earlier, when you're in the examinations, it's a race against time. having these answers, these short answer questions to these basic questions that you know that they might ask you would help you. That way you're just transferring information that you've already prepared, you've already thought through, and you're just transferring them into your examination answer, okay? So it's very important to go through and see what these questions are in your syllabus as you're reading and just highlight your answers to them, okay? Do we have any questions so far before we start discussing the content? Is everybody here? Yes? Estella, nothing? No questions? Okay, perfect. So if we started, for example, and we came to class and we're going to start talking about Section A, I would point out the things that are really important for you to note, okay? So when they talk about professions and professionalism, it's basically talking about the law as a business. There's a sentence that the syllabus uses, the law as a business or business of the law, okay? So it's considered that the law is not just the practice that you and I know. The law is also considered to be a practical business, which means we're offering services to clients. And so we're not just looking at the content of the law and what the rules are saying, we're also trying to make sure that we're managing our practice in such a way that we're considered as ethical. One thing you should note about ethics and professional responsibility in Canada is the fact that not only are they able to look into your professional activities as a lawyer, they can look into your personal activities as well if the law society feels that it would bring disrepute to the practice of law as a profession, okay? So professional responsibility and professional ethics is not just looking at ethics as a body or as a concept. It's also considering your actions as a lawyer or your ethical responses or how you carry out your activities in response to those rules and obligations and what is required of you. Now, you should note that the law is seen as a profession, and by seeing the law as a profession, you're upholding the public, the tenets of the public, you're supporting the public. You're not just carrying out a practice on your behalf, on your profession's behalf, but you're making sure that the whole profession as a whole is represented in a good light. So anything that you would do that would misrepresent the profession as a whole is frowned upon. And these are the rules that are listed in your Modal code, okay? If they ask you, for example, what is a profession? A profession is defined as a paid occupation, one that is found upon a specialized and often prolonged educational training and formal qualification. So what are they saying? They're saying that although there are many jobs, many people go and have careers, the professions, for example, medicine, for example, law, there's specific attributes that they have that stand them out. And one of these things is you have to go through rigorous education and qualification to get to that level where you're considered as a professional. They self-regulate. So most times professionals regulate themselves. Most other occupations have external bodies that focus on these professions and say, oh, what you're doing is wrong. We don't support it. And they look into the actions of those people, so maybe like the labor organizations and things like that. But for professions, they hold you guys in such high esteem that they expect that because you're experts in your field, you yourself should govern what occurs amongst your members. So those are one of the things about professions, okay? It's also a paid occupation, and it's also a specialized occupation. So they expect that not everybody in society understands the nitty-gritty of the functions of your profession. So that's why you have to go through rigorous educational training. In other jobs or careers, they can train themselves, they can go online, they can go for courses. Whereas things related to law, you have to go through a specific training, a specific JD course, a specific LLB course for you to understand before they believe that you understand the course itself, okay? It has an autonomous governing body. Members demonstrate expertise in their field. And of course, like we know, it's self-regulated. So the disciplinary action of its members is governed by itself, okay? Another concept that you should understand that I already touched on, you should understand the fact that public interest is really intrinsic to us, our practice as a profession of law. So public interest is not just an abstract notion. It's that all the things that we're doing, all of our activities have to point towards supporting the public interest. So you're not going to be allowed to do anything that contravenes that help of public interest. Okay. Now there's also this question that they constantly ask: law as a business, or is law a business, or is it considered as the business of law? Now there are two opinions of thought. The first one is that some people see it as a noble practice. It's a noble calling. There's this history of law that if you look at your gown, there used to be a little pocket at the back. I think we have a little tab on the back right now. It's not a pocket anymore. But they just thought that it was so noble that you couldn't start asking your clients for fees. At the end of representation of a client, they would just put whatever they had, their money, into the back container, pocket, whatever. But nowadays, in today's practice, we've realized that law is actually a business. So we do need to carry it on as a business. We need to know what our client requires. I know in some common law jurisdictions, advertising is not allowed. In Canada, there's just a regulation of laws and requirements within which you can advertise. So it is allowed as long as you're not misrepresenting yourself, as long as you're not stating that you are the expert. You have to be stated as an expert by maybe external bodies or external people. You can't, there's certain parameters within which you can advertise yourself, okay? And that if you're going to practice law as a business, you do need to balance professionalism and the business. You can't just say, oh, I'm a professional, so I'm not going to focus on the business aspect. Neither can you say it's fully a business, I don't really care about my clients, I'm going to focus on the fact that we need to make money and generate money. Which is why in the practice of law, we do have, which we'll discuss in section D, pro bono aspects, where we have to offer services to clients pro bono, because we know that justice is one of the paramount things that we're chasing, okay? Obviously, all of this is not new information. It's something you've probably heard in your own common law jurisdiction. Now, the practice of ethics itself is another major, or the discussion of ethics itself is another major topic in this section. So we have things like what are the sources of Canadian professional responsibility? And the sources of legal ethics are case law and legislation, rules of professional conduct, which you have and can download, the disciplinary decisions of your law society, and the principles and norms of lawyering, okay? So by saying just the Modal Code of Professional Rules of Professional Conduct, that's not enough, because from various case law, there have been sources that have arisen. For example, if a new thing occurs in law and it's taken before a panel, it hasn't been done before. So we are like, oh, is this actually a negative thing to the profession? And there's a ruling in the on the disciplinary panel that it is wrong. It is then added as a source of professional ethics and might be added to your Modal Code when there's a refresher or a re-edit in the commentaries, so that it is constantly evolving and it's constantly developing. Case law and legislation, also dependent on things that occur in various case law, are seen as sources of professional ethics. So if you look at your syllabus, there are two cases that are added as appendices, the Goya case and the Trinity Western case. Those are examples of case law as sources of professional responsibility. Now, when discussing ethics, there are various schools of law in the discussion of ethics. There are 5 schools of law. There's the virtue ethics, utilitarianism / consequentialism. So it can be called utilitarianism or consequentialism. There's the Kantian or deontological theories of right action. There's also postmodernism and pluralism. Okay, my notes. So I just want to give you like an explanation of what these things are, what these schools of law are, because I know that a lot of time people start reading professional ethics and they zone out, because section A or part A is very heavy in content. So it's not as easy as practice. It's basically articles and information and theories, so you can zone out. I know a few people who would start reading Part B, Part C, Part D, and come back to Part A. In the intensive classes, we will start from Part A, because I feel like it's better for you to have a foundation of the course before you start discussing the practical aspects. That way you understand where the practical aspects are from. Okay, so virtue ethics is easily understandable. It's based on your moral compass, where they believe that all men know right or wrong, all men know what is good. So ethics is based on that general knowledge of what is right and what is wrong. Okay, now utilitarianism, the case for utilitarianism and consequentialism is Aaron Murray. With utilitarianism, it's what is practical, what are the consequences, what everybody sees that there's an end result or an end game to anything that you're carrying out. Okay, so they believe, that school of thought believes that once it's not just ethics as a practical concept, it's also how you carry out this ethics, your actions, what the lawyer is expected to do. Okay, those are the things that are considered in that school of thought. Yeah. Now, the Kantian or the deontological theories of right action, they are rule-based. It's a rule-based school of thought. What is the rule? What is the established law? What is stated? What is already written down and codified? If this is what the law says, this is what we're going to be abiding by. Whether it's moral or based on your religion, it's wrong or right, it's a rule, and we're going to abide by that. Okay. Obviously, when you read through the schools of thought, there are more postulations, there are more discussions on it. You would find out that some are opposed to the other types of schools of law or schools of ethical thought. You would find out that some of them are totally contrary on different aspects of the spectrum. Okay. Now, Post-Modernism says that a person can't be removed from his impulses or desires. Okay, so even if you're saying that people are ethical, usually they're ethical based on what they want, what they're trying to achieve. Okay, if my desire is seen as negative by my society, I would say because it's my desire, I'm going to act on it. But what if it's contrary to the rules that are already established? Okay, so people are saying that school of thought is saying that the ethical discussions, you can't remove a human being's desires and his wants and his motivations. Can we please mute our mic? The Lord, hello? Okay, perfect. And then there's pluralism. Pluralism simply states that there are various values that you have to consider. You can't just think of one ethical school of thought. You have to realize that you have to weigh and measure the various schools of thought and bring a combination of all of that to understand that you can't just think of one direct school of thought. You can't think of one, your mind can't be narrow when you're considering ethics. There are various things that you have to weigh and measure to consider the discussion of ethics. Okay, so that's basically what is discussed in Section A. Lawyers' obligations to themselves and their clients. What is your duty? Requirements of an ethical lawyer. So it talks about lawyer advocacy, standard conception of the role of law, and then lawyer as a moral and neutral actor in the practice of law. Okay, there's an article there by Trevor C. Farrow, The Regulation of Lawyers and the Regulations of the Legal Profession. It talks about basically the dominant aspect of legal ethics, the sustainable professionalism, dominant professionalism, and alternate ways that we can consider professionalism. I'll explain what dominant professionalism is. So his article basically is telling you that in the old concept of consideration of law or legal ethics, it was seen that the lawyer was a zealous advocate. They use that word a lot, okay? The lawyer is a zealous advocate. The client is king. Your client's roles and objectives are what you should focus on. You shouldn't focus on anything outside. Your own opinions don't matter. What you're fighting for is to fight to pursue your client's objectives, okay? So it doesn't matter whether your religion is contrary or what you believe is wrong or it's against what you believe. Once you're practicing dominant professionalism, basically the client is king. And he was saying that in today's practice, this isn't really what is considered as right, because if you ask any law student, a law student will tell you, going into the practice of law, we're going to focus on the client. I'm going to work from all hours of the day. I'm going to make sure that the client is, all the client's needs are met, to the detriment of your own family life balance, your own objectives and wants and desires. But they're now saying that there's a sustainable model where it can be balanced out. There are other alternate concepts of professionalism that will be considered, but they're saying there should be a sustainable model where you can consider the fact that a lawyer can have work-life balance. The client is only king. You have to consider things like the public interest when you're pursuing your client's interest. You consider the client's objectives as well. You have to consider yourself as a lawyer, whether it's you're in line with, because if you do not agree with what your client is saying, then you can't be a competent lawyer if you don't offer the duty. You have a duty of candor by being honest with them and telling them this thing that you're pursuing wouldn't work. These are the aspects that I think will, these are the aspects that I think won't. If it's a dominant part, you're just trying to pursue your client's objectives, and that wouldn't really function. Although they're saying that in the dominant professionalism or the dominant conception of this, it's what is portrayed in the media, it's what is portrayed in shows like Suits, it's what is portrayed if you're discussing with old-time lawyers. They all feel this is the way that law should be practiced. So he then goes ahead to make suggestions by saying, if you're teaching law students while they're in school, if you're teaching them while they're in law school about this sustainable model, and we're pushing out lawyers into the profession that understand this sustainable model, it might be possible for us to change this idea of the fact that lawyers are focusing just on clients, focusing just on the obligations without a consideration of themselves. Okay? It's a long article. I think you should read it. Summarize it in your own words so that if you have to refer to it, you would be able to refer to it in the exams, okay? So I think we've gone through most of it. We talked about self-regulation, sources and meaning of opportunities of self-regulation. If you joined us late, this video would be on our YouTube page, so you should be able to watch it back to catch up with what we've discussed and all of that, okay? Okay, so let's go to section B, which is a more interesting aspect of professional responsibility. Now, this is where we're dealing with conflict of interest and confidentiality, okay? Now, I always, in my classes, I always try to build towards the concept. So I always start with the fact that you should always note that the legal profession is a fiduciary-based relationship. So with your client, you have a fiduciary duty to your client. It's just, and it's a well-known thing that lawyers have a fiduciary relationship or duty to their clients, okay? Now, in having a fiduciary duty to your client, there's some things that you would expect. You owe your client a duty of loyalty, okay? Now, this duty of loyalty owed to your client, from the case of Aaron Neal, it explains to us, it breaks down this duty of loyalty into 3 parts, okay? Some people refer to these parts as the 3 C's, all right? So your duty of loyalty entails duty of candor, duty of confidentiality, and duty of commitment to your client's cause. So duty of candor, duty of confidentiality, and duty of commitment to your client's cause. Those are the 3 C's. Now, under this duty of commitment to your client's cause, we can infer one of the duties mentioned under that is a duty to avoid conflict of interest. Okay. So did you get the way I structured it for you? So if, for example, you were explaining in your examination, it's a very good way to establish that you understand where these concepts are coming from. It's not just because, for example, people go into the examinations, you read a scenario, and you're like, oh, there's conflict of interest. No. The issue that has arisen in that scenario is a breach of your duty to avoid conflict of interest. You should actually structure it in that fashion. Okay? Now, conflict of interest is seen in section part 3 or rule 3 of your Modal code. But before I even go into that, I'm going to be referring to the word competency a lot. Competency is defined in your Modal code. Does anybody have their Modal code open? Anybody? No?
Yes, I do.
Okay, can you help me check rule 3.1 and read us the definition of competency or competence?
Okay.
3.1-1.
So what do you want me to read?
3.1-1. It defines competence.
In this section, competent lawyer means a lawyer who has an applied relevant knowledge, skills, and attributes in a manner appropriate to each matter undertaken on behalf of a client and the nature and terms of the lawyer's engagement, including A, knowing general legal principles and procedures and the substantive law and procedure for the areas of law in which the lawyer practices. B, investigating facts, identifying issues, ascertaining client objectives, considering possible options, and developing and advising the client on appropriate courses of action. C, implementing as each matter requires the chosen course of action through the application of appropriate skills, including 1, legal research, 2, analysis, 3, application of the law to the relevant act, 4, writing and drafting, 5, negotiation, 6, alternative dispute resolution, 7, advocacy, and 8, problem solving.
Stop there. No, let's stop there. So that is the definition of competency in the Modal code. Now, one of the things I'd just like to say is, for example, did you see that there was so much content in that definition of competency? So, for example, if you're trying to define competency in your exam, or because a lot of what you're going to be responding to, you would have to refer to these basic concepts that are stated throughout or scattered throughout the Modal code and throughout your notes. So one of them is competency, one of them is quality of service. Competency also covers language rights. You can't be a competent lawyer if you do not abide by the language rights. What are language rights? Your client has a right to be served in the language that they best understand. They have to understand what you're saying. They have to be able to compute with it. If you cannot serve them in that, you're supposed to offer them services of another lawyer who speaks their language and can explain it to them in their language. You won't be seen as a competent lawyer if you take on a service and this is one of the things that you don't meet. So there are very little intricate details about being a competent lawyer, and almost every question that you have to answer, you would mention competency. The first thing you say is, oh, this is not ethical because it doesn't expound the values of competency, the values of integrity. You do have to let them know that you're aware of these various ethical values that are in your notes, okay? Now, we read the definition or the Modal code's interpretation of competence, okay? In my abridged index that I created, let me read you what I put in there as competence. So I put there's a line that says a competent lawyer, there's a definition for competent lawyer and its requirements, but then I put a sentence that you can use when you're trying to define competent lawyer, which is one who has and applies relevant knowledge, skills, and attributes in a manner appropriate to each matter undertaken on behalf of a client and the nature and the terms of the lawyer's engagement. So obviously all that information has been compressed into one sentence. So basically you look at it, you know that competence is in 3.1, you check your abridged index or your annotated index, you get the definition you need and you place it in your examination, okay? Now, why am I talking about competent lawyers? Before you even start talking about things in section B, like conflict of interest, breach of confidentiality, you do have to let them know that you're aware that a lawyer needs to be a competent individual, a competent lawyer. He's expected to carry out some certain activities. He's expected to have integrity. And if any of these aspects affect the scenario that they've given you, you raise them before you go in to start discussing the fact that there has been a breach of that duty to avoid conflict of interest, okay? Is everybody aware of, well, not everybody will be aware, but the NCA structures their answers in the IRAC method, the issue, the rule, the application, and the conclusion method. Although I know some people are aware of this method, if you've written any NCA exams before, you're aware of this method. But if you're from another common law jurisdiction, you might not be. Now, the way the exams are structured, although you have all this information, you know what they are, they expect you to structure it by writing out it in that specific statement. We have our last class of the intensive classes is an exam preparation class. So we have this introductory class, we have the intensive classes, and we have an exam preparation class where we're specifically, you finish reading, you have all the information. We're now discussing how to answer your questions, okay? That class is usually open to the public, everybody. You don't have to be a member, you pay for it and you join. Now, the things we discuss is the fact that issue, rule, application, and conclusion. Your issue is usually the question that they have asked you in your scenario. So the last line of your scenario will be your issue. You redraft that question that they've asked you and you place it as your issue. If they ask you, what are the consequences of this lawyer's actions, or what are the ethical issues that have arisen, that is what you rephrase and you state as your issue in the question. Now, your rule, you always have to mention the rules that apply to whatever you're discussing. So if we were talking about conflict of interest, under rule, you would go ahead and mention rule 3.4-1. If you want, you can go ahead and mention the commentary that specifically relates to what you're discussing. You talk about rule 3.4-2, commentary 6, commentary 11, example D, that's the one that talks about sexual relations with clients, because I've spoken to a lot of candidates and a lot of people are not even aware that that is in the model code. Okay, you specify your rules under the rules section. If you go to your model code and there's a cross-reference, for example, one of the rules you're reading says refer to section 3.1a, you put that as well in your rules because it's a reference referring to the concept you're discussing. Then your analysis is where you now discuss the issues or the information that you have, okay, from what you've learned. Now, in relation to conflict of interest specifically, I already told you what the introduction of our analysis would be. We will talk about the fiduciary relationship. We would mention the fact that there is a duty of loyalty. The duty of loyalty has these 3 C's. We go ahead to say that under this duty to commit your client's cause, there's a duty to avoid conflict of interest. You see, we have built our case up onto conflict of interest. And then we go ahead to then discuss the details and the nitty-gritty of conflict of interest. Okay? Did everybody get it thus far? Right? And then not only do you have, under your duty of conflict of interest, we now go ahead to break it down to now say that you have a duty to former clients, you have a duty to your current clients, and then you have a duty of loyalty to existing clients, whoever your existing clients are. Okay, so these 3 are different in that you could have served a client in the past and you're no longer in that law firm. You still have a duty to that client. Then you have current clients. Okay, you have a duty to the people that you're serving right now, the services that you're offering. Okay, but your duty of loyalty is such a fact that it ties you to both clients in that your offering of services to your current clients cannot hinder the information or the confidentiality or all that you have gained from serving the former client. Okay, so if you have information from serving an old client that you are now using in this case, or that under a reasonable man's mind you are going, you know that that particular client has this information and it's going to help you in this case, there is a conflict of interest there. It has arisen. And once conflict of interest arises, there are certain things that you have to then go ahead and do. All of this is written in your modal code in section 3.4. Okay, so you first check. There's a, let's see what the list is. So you consider the factors. There are some factors that you consider. There's about 6 of them. The immediacy of your legal interest, whether the legal interests are directly adverse. There's a phrase, directly adverse. The interests have to be directly adverse. Whether the issue is substantive or procedural, the temporal relationship between the matters, the significance of the issue of the immediate long-term interest, the client's reasonable expectations in retaining the lawyer for particular interests. So you list these things and say that these are factors that are considered, and then you can expand on it. So for example, when I was talking about the directly adverse, both clients, if you're representing clients in a matter and there's a discourse, okay, they're directly adverse, they're on opposing sides, there's a dispute, there's an issue, they're on opposing sides, there is conflict of interest. It has arisen, okay? Now, under normal circumstances, if it wasn't a directly adverse issue, okay, and it was maybe immediacy of interest, my client wants to buy land, and this other client owns the land. So obviously, there's an immediacy of legal interest in that representation, but there's no discourse. What the ethical thing to do would be, or what the law expects of you, or the code expects of you, is to seek the consent of both clients, both your former client and your present client. If they grant you consent, then you can go ahead and represent, okay? If they grant you consent and you go ahead and represent, as an ethical person, at every point in time, you have to show that you're trying to maintain your integrity. You go further to ask them to seek, you offer them the opportunity to go ahead and seek independent legal advice. They might decide to take it or not take it. That is up to them. But you have to show that you have asked them to seek independent legal advice as well. Okay? So with conflict of interest, there's some steps that you need to follow, and we'll discuss this in detail. Now, with that directly adverse interest that I mentioned, there's a rule under conflict of interest called the bright line rule. Now, the bright line rule originated from the case of Ncaa, the Ncaa case, and it stated specifically that if there is, let me see if I have the exact statements that were said in that case. So the court held in that case that any concurrent representation of clients directly adverse in interest attracts a clear prohibition. So what we were talking about, if I draw us back, you said, oh, fine, I realize there's a conflict of interest. I've gone ahead and I've spoken to the clients and I've said, okay, I realize there's a conflict of interest. The first thing I do is I declare my conflict of interest. And then I now want to ask you and say, can I concurrently, both of you have given me your confirmation that I can represent you. So the statement there is, I am concurrently representing the clients, okay? You can concurrently represent, for example, a husband and wife. Maybe they want to go through divorce proceedings. They've already had a discussion. They're very civil. They have no issues. They already know who's taking what. They've already divided assets. They just need you to be their lawyer. They've given you consent to represent them concurrently. If at any point their interests are directly adverse, like there's a fight, there's an issue, there's a clear prohibition for your representation of those clients. Okay, you cannot, under any circumstances, represent them. That's what the bright line rule is saying. Okay. Now, obviously, like every law, there are exceptions to the rule. So the exceptions to the rule of the bright line rule is if the bright line rule is going to be used as an instrument of fraud, if it's going to be used as a tactical abuse, it cannot be raised by a party who seeks to abuse it, use it for fraud. So let me give you an example of fraud, okay, or a tactical abuse of the law or the bright line rule. So say I'm the lawyer of a big corporation, or I'm a big corporation, and I'm aware I have a legal team, they've done all their research, and we're very aware of the bright line rule and conflict of interest. So we go ahead and say, okay, fine, who are the top law firms? I live in British Columbia, so I would say, who are the top law firms in Vancouver? Okay. Now, we take a list of maybe 20, don't let me say 50, that might be a bit too much, 20 law firms or 20 law firms, the top law firms in the province. And we take them and put them on retainer, okay? Which means each law firm is a lawyer to my organization, right? But the reason we did that, or the reason we actually went ahead to do that, was because we realized that if we have a lawyer representing us in all these firms and we have an issue later, we're thinking that those people who have issues with us would not be able to use those law firms because we'll say, oh, there's a conflict of interest, and as such, those firms cannot represent those clients. Now, that's a tactical abuse of the bright line rule. Do you see how it can be, it's being abused? Because they know that, oh, they can rely upon the fact that they say, oh, this conflict has arisen, and as such, you can't represent them. If things like that happen, then the bright line rule cannot be afforded. The courts will write it off. The conflict of interest or the bright line rule would not be applicable in that case. Okay? Does anybody have questions so far? Yes? No? Are we fine? I'm looking at your faces and you're...
Yes.
Okay.
Yeah,
Hi,
I
Chief.
just have I have a question, and actually it has to do with the model code. Looking at the syllabus,
Okay.
in some, like when you reference the competence rule in 3.4, I see
Okay.
that the syllabus sometimes mentions like chapter 3, and then it mentions rule 3.4.
Okay.
And then between that chapter 3 and rule 3.4, there's just a comma. Is there expectation that we study the whole of chapter 3 or just specifically the 3.4?
When we say study, you need to study the whole model code.
So if you look specifically at the under the required readings for conflicts of interest, the first one is page 8 of the syllabus.
Okay.
So the first thing there is casebook, chapter 5, that's clear. Then the second is model code, comma, chapter 3, comma, rule 3.4, and commentaries. So my question is, do you read only, because 3.4 comes under chapter 3,
Yes.
do you read only 3.4 and the commentaries, or are you expected to read the whole of chapter 3 for purposes of conflict of interest? I know that 3.4 deals with conflict of interest, but you know.
Okay, I get you now. So specifically, what they're doing here is they're just showing the breakdown of how to get to where they're taking you to. So with regards to conflict of interest, they can't give you we understand that if it's rule 3.4, we already assume that 3.4 is under chapter 3, but they're just writing it out the specific way. Model code, then you open chapter 3, and then under chapter 3, you go to rule 3.4. That's the only part that's referring to conflict of interest in this regard. Chichi, did that make sense?
Yeah, sure, thanks.
That if you haven't seen the model code before, they won't want you to just keep flipping and looking. There's an index attached to the model code. So you go and look for chapter 3 to tell you the page, you open that, and when you get to chapter 3, you're going to be looking for 3.4. So not the whole of chapter 3. Chapter 3 deals with a myriad of things: confidentiality, privilege, if you were in an old firm before, if you're in a new firm, you're an articling student. There's so many things in Chapter 3. So you're right. This is specifically talking about Chapter 3, and then you narrow it down for conflict of interest 3.4 and commentaries. Does that help?
Yeah, thanks.
So another thing I'd like to point out before we move on, I just wanted to focus on conflict of interest because it is a part that people have a lot of questions with. It can be confusing. After you talk about the bright line rule or dispute bright line rule when relating to conflict of interest, you talk about the substantial risk rule too. Now, the substantial risk rule is just it's like a covering of bases, okay? If let's go back to the fact that as a profession, as a lawyer, as an ethical lawyer, a competent lawyer, you're supposed to make sure that all your actions are competent. There's actually a part in the Modal Code that states that a lawyer you should ensure that you're not used as an instrument of dupe. And there's even a recent case that happened, I believe it was in Alberta. Where a lawyer was disciplined and she was suspended for 3 months from her practice. And they specifically stated that she unknowingly she was an unknowing party to a fraudulent act by her client. Her client had fraudulently done some mortgage issue or carried out some mortgage, and she was unaware. But although she was unaware, she was still disciplined and suspended for those 3 months because the Modal Code specifically says that you shouldn't be used as an instrument of dupe. So you have to cover all your bases when you're dealing with the clients. You as a lawyer is the person that should ensure that everything you're doing is of a high standard of integrity. So fine, we've seen this conflict of interest. We've raised that issue of conflict of interest. We've asked for their consent. We've looked at the bright line rule and seen that it's not applicable, but you still have to check the substantial risk. You have to check whether your representation of the new client has no substantial risk to the former client. So my representation of you is not going to cause any negative or adverse effect to my former client. If you are in any way against my former client and my representation of you, you're winning the case, would adversely affect that former client or my other client, then I also cannot represent you. Okay, so that's just, you've seen it, you've looked at all the rules, it still seems like it's plausible. You still have to go the extra mile, okay? And just make sure and check and see that, oh, there's no way that I'm going to affect my other client. When you're looking at, so let's move from conflict of interest. We don't have that much time anymore. You look at confidentiality. You look at the issues and the details that are required. When do you stay confidential to your client? What information do you keep confidential? Is being confidential, holding information confidential in a litigation case the same that is observed when you're the solicitor in this instance, or if it's a trial? The general rule is that if it's a litigation matter, you're holding the information of that litigation matter from the start of the trial to the end of it. Once the trial is over, you are not obligated to hold the information for that particular trial confidential. You're done. But when it comes to things like solicitor-client relationship, before you even start that relationship, there's quite a bit of information that is given to you as the lawyer. So there's so many things, like there's a case where a husband was having issues with his wife, and so he had a lawyer. The lawyer and him were having discussions relating to a labor issue, but also discussions. I found out that he was having issues with his wife. His wife apparently was working in the law firm, maybe a receptionist or legal admin, something. And by knowing that there were issues between his client and his wife, he went ahead to have a relationship or an affair with his client's wife. Now, the information that he garnered from helping his client with that labor issue gave him confidential information about his client's family or marriage relationship. that information he cannot use or she cannot use to her benefit or to the benefit of a third party. That information is considered to be confidential information, and confidential information, he's expected to keep that information confidential throughout the relationship. He constantly has to keep it confidential, even at the termination of their relationship. Okay, so you have to learn the differences between the information that you can keep confidential, when does it terminate. You have to learn about when does the client-lawyer relationship actually kick in. So when is it formal? When is there a formality as to when the relationship is instigated? Formation of a relationship. In the past, it was seen that formation of a relationship between a lawyer and a client usually at the time of signing a retainer. But over time, it's been seen that when a client comes to you, for example, you work in a law clinic or you are giving free advice, they have to release some information to you first for you to decide whether it's something you're going to go ahead with, okay? And if they've released that information to you, can you come back later and claim that, oh, I'm not this person's lawyer, there's no retainer yet, so I can share this information? So the law or the idea or the rule behind that is, once the client believes or relatively believes that you are their lawyer and you're representing them, the relationship has automatically kicked in. The lawyer-client relationship has been formed. Okay, so in some instances, we haven't gone ahead to formalize it by signing the retainer or by signing a document, but the client relatively believes that our relationship has been started and there has been a formation. Then it's agreed that the formation, the lawyer-client relationship has kick-started. Okay, this rule doesn't like office of an organization if you are the lawyer to the organization. So an example, I am a lawyer to a firm, a bakery, an organization, they're a bakery, they make cake and all of that. And their CFO or one of their employees keeps coming to me to ask me about the organization. I am still the lawyer for that organization. Our discussions does not create a client-lawyer relationship between me and the employee. The employee cannot wake up in the future and say, oh, but you're my lawyer, we have had a few discussions. Okay. Can everybody still see me? I'm getting a notification that there's some issue with the network. Are we still on? Yes? Can you hear me? Yes, perfect. Okay. So you have to understand, look at your client, a lawyer in an organizational setting. When does the relationship actually kick in? Who is the client in this relationship? A lot of time you will get questions where they will try and confuse. I always call it white noise. A lot of the PR questions that you get, they're trying to confuse you, give you a lot of information. What we're doing in professional ethics is we're focusing on the lawyer. So if you look at past questions, always focus on the lawyer. What are they saying the lawyer did? What are the actions of the lawyer? Did these actions breach any ethical observations? Whether he's this or that, or he spoke to that person, he's his friend. No, you're looking at his actions or activities as a lawyer. Okay. So if we're then looking at the lawyer in an organization, his actions towards that organization. Did he keep their information confidential? Is there a breach of a conflict of interest by representing somebody else? Even with conflict of interest, there's a whole section about former clients. So if you're an articling student in another firm and you move to another firm and for example, now against your former client, what are the guidelines and steps that you need to take? So there's a list of guidelines in the Modal Code that states the things that have to be done by that firm before they can go ahead and represent. And that list contains things like sending information to the former client, ensuring that the person or the new articling student or the new associate is not involved in this case, knows nothing about the case, handing the case over to somebody else in the firm. So if you even have issues of conflict of interest, for example, and you're a 4-person firm and you've ascertained that there might be conflict, you can cure this conflict by actually handing over that matter to somebody else in the firm and making sure that you have no hand in it, you're not involved. So those are some of the cures. So as you're looking through your model code and reading your notes, highlight what you see as cures, because when you finish your analysis and discussing the information and all the rules and what you know about it, then it's also ideal to mention that, oh, so in this instance, we will cure this by either walking away from the transaction and not representing the client, handing it over to another lawyer, ensuring that the guidelines are met, and we're making sure that that person who the conflict arises with is not a representative on this particular case. So always mention your cures. Then your conclusion is basically, or what you're going to see at the end is what my opinion is. I think this and this and this should happen. Sometimes they might be asking you about lawyer sanctions and punishments. It should be noted that there's nowhere in the model code that actually codifies lawyer sanctions and punishments. It's not written anywhere. Most of these lawyer sanctions and punishments are gotten from case law and results of disciplinary actions, all the other various sources of professional responsibility. Okay, so some of these things might now be fines. There are cases that have fines, cases that have disbarment, cases that have suspension. So you would come up with a list of things that you feel are sanctions that can be used against that lawyer in that case. There's also a question that comes out a lot, which is what would you, and this is a common response, what would you do to improve the model code as it presently stands? And that's one of the things candidates actually suggest, that maybe there should be a codification of punishments and sanctions. There should be at least a structure or framework that should be followed whenever a disciplinary action is taken against a member of the bar. Okay? When we were talking about client and organizational settings, there was something else I wanted to mention. There's a rule. It's referred to as the up the ladder rule. Okay? When a fraud is committed by an organization, okay, they expect you to follow the up the ladder rule. Now, where does this arise from? If any of you are aware of the N1 case, it's an American case, it's not Canadian, but it's the origin of this whole thing. The N1 case was a really big corporation that collapsed due to fraud by its members and its executive board and directors, and they realized that the lawyers were also involved. So if you could Google the Enron case and just read about it, it's just good to have the information. It was after this occurred that they realized that they needed to come up with things and structures to ensure that the lawyers in practice or the lawyers in organizations are not dragged into these fraudulent practices and therefore bringing disrepute to the profession. A lot of the disciplinary action and a lot of the actions of the law society is just to ensure that our integrity as a profession is upheld. Why? If you read the start of your course, professionalism and the regulation of the profession is because one of our main pillars of our profession is integrity. We wouldn't have clients if they didn't believe that they could trust us. Nobody in the society will come to hire a lawyer. If we breach confidentiality, nobody's going to hire you because they're going to feel that the information, you're not representing them right. If we breach confidentiality, they'll feel that their information is going to go out. If we breach and we conduct conflict of interest cases, they're going to be like, well, the lawyer isn't representing me. So a lot of it is geared around protecting the interest of the public, protecting the interest of the profession. You're not just looking at it as I'm one person practicing. You always have to look at it as it's a full profession, and we have to uphold the tenets of integrity of that profession. Now, going back to representing an organization, being a lawyer in an organization is unique in the fact that if you're a law firm, you have 15 to 20 clients, if not more, and you're getting income from all these clients. A client doesn't work with you, doesn't really, you guys have some adverse interest, you can walk away. When you work for an organization, they're the ones paying your salary. They're your only client. So any issues that you might have with them, you walking away is a detriment to you as a lawyer because you're losing funding, you're losing your income, you're losing, do you understand? You're losing your job, basically, right? So they've created this up the ladder reporting system. If at any point you're working for an organization and there is an issue of fraud, they expect that the first step you will take is to let the person that you relate with in that organization, probably your chief legal advisor, you report the issue of fraud to them first and ask for it to be cured. You give them a reasonable amount of time. If the fraud is still being perpetuated, you move it up. You report to the CEO. You tell the CEO there's this issue of fraud, I found some documents and all of that, and I'm just letting you know so that you can look into it. It's not your position or your place to go ahead and start pursuing what the issues are. You tell the CEO. If you tell the CEO and the fraud is still not cured, you take it to the board. Okay, all of this is written in your model code. It's reporting up the ladder. You report to the board of directors. This is the issue that has arisen. I would like it to be looked into and cured so that basically the fraud isn't perpetuated. It's after you've reported up the ladder and nothing is done, then you go ahead and then you can withdraw your services or resign your representation. Because if we go back to part B of the course, talking about formation of the client-lawyer relationship, there's a list of things or triggers that can terminate your relationship. You're not expected or allowed to walk away from a client. If a client is going to be in a detrimental situation when you walk away, if they can't find alternative representation, if it's too close to their trial date, you cannot pull out. So there are various things that occur. You can't just say we have differences on opinion and pull out or withdraw from representing your client. There's a whole list of things that you have to note in client representation. But when it comes to an organization, if you've reported up the ladder and nothing is done, then at that point you can withdraw your representation from that client and you're justified for withdrawing your representation from that client. Okay, do we have any questions thus far? Do we have any questions, issues? No? Yeah? No? Okay. Okay, so when we're talking about lawyers, sanctions, and lawyers' misconduct, there are a few cases that I'd like you to note, because these cases are the one that brought about the various sanctions that I was mentioning. So there's Adams and Law Society of Alberta. Okay. There's LSUC and Bolt, BOLGT, Bolt. There's Lameman, LAMEMAN, and Alberta. Lameman and Alberta. There's Law Society of Alberta and Beaver, so BEAVER, Law Society of Alberta and Beaver. And there's LSUC and Hunter. So these are all different cases that have different sanctions attached to them. And these are the sources of these sanctions in professional responsibility. So where one of them was given a fine, a 60-day suspension, you can use that as an example. In Adams, he was disbarred. Even though he challenged his disbarment, it was still approved. I think it was Hunter where he was given a 60-day suspension and $2,500 cost. And I've seen a question in professional responsibility where they asked that if a lawyer was issued cost for a disciplinary action, is this cost going to be paid to the client or the law society? And obviously, well, not obviously, but the cost is paid to the law society, because the client has brought the matter towards the law society for disciplinary actions and saying that this client has done things that are unethical, and the law society is looking into it. So any cost that has arisen, the cost isn't really to pay back the clients for any issues. It's just basically trying to tell the lawyer you've done something wrong and you must be punished, and so there's a cost issued. Okay, there are a lot of questions apart from the scenario questions that are short answer questions. It can be true or false questions. Is this sentence true? You go ahead and explain the information or the course content under that concept, and then they might tell you rephrase the question if it's false to what would make it true. So you list the rule in the model code that applies to the question. You talk about all the information from your notes, these are the points, these are the exceptions, these are the laws, this is why this is done, you conclude, and then you go ahead to say whether it's true or false. So a lot of that also applies. So when you read things like section A, and it doesn't look like a scenario can come from it, it can be a short answer question. Okay, you should note that. And I also wanted to talk lastly on confidentiality and privilege. Okay, that's the last thing I'm going to talk about. So the difference between confidentiality and privilege. So if you're thinking of it in a pictorial way and very visual, the core, think about having a circle that has a core, a smaller circle and a bigger circle. The small circle is seen as privilege, and the bigger circle is seen as confidentiality. Okay? Now, with confidentiality, there's no contract, there's no retainership. There has been a discussion. Okay? There is an ethical duty. It's a broad picture. It's a broad overview of a lot of things. We know that it's Modal Code 3.3.1, I believe. And it's an ethical duty that you owe to your client when you're discussing confidentiality. Okay? Now, privilege is more narrow. Privilege is a legal duty that you owe to your client. Okay? It could be ethical, which is why it's the smaller circle in the bigger one. Confidentiality covers everything that privilege covers, but privilege itself is a legal duty. It could be ethical. There's an end to privilege. For example, when I said you're going to trial for a particular matter for a case, there's obviously an end to that trial, and as such, your privilege based on the information of that particular trial will come to an end. But it's definitely embedded in confidentiality. Okay? So there are two different types of privilege. There's solicitor-client privilege, okay, which obviously it's an exception to confidentiality when you can break your duty of privilege. And there's also litigation privilege. That's the second type of privilege. Litigation privilege is communication and documentation that's created for the purposes of litigation. So you got documents for the intention of that particular litigation. You got documents like receipts, you got documents like opinions from experts. You have that information as privileged information just up until determination of the litigation issue. Once it's done, all that documentation could be returned, all that information is no longer privileged, okay? Now, the exceptions to confidentiality, which I didn't mention earlier. And one of these exceptions is a crime fraud exception. So if your client is committing or about to commit crime or about to commit a fraudulent act and you are aware of this information, you are obligated as the lawyer to declare it. Okay? And the case for this is Descotteur and Merzwinski. Descotteur is DESCOTEAUX and Merzwinski is MERZWINSKI. Don't forget, this recording is going to be on YouTube, so you should be able to go back and get the information. Okay? There's an exception apart from crime and fraud. The next exception is public safety exceptions. I'll say something that's really out there. You're a lawyer to somebody and you hear that the person is creating a bomb, for example. You can't keep that information confidential because people in the public are going to be harmed. Or the person is a rapist and he has plans or had plans to be in a certain area and the women in that area are not safe. So there's a public safety exception, and this is paramount. You have to declare that information if public safety is at risk. Okay? There's also the innocence at stake. Okay? If there is any doubt or there is any way to show that somebody who's innocent might be going down for a crime, and you have that information, you need to declare that confidential information. They would prefer somebody innocent to go off than being locked up as being guilty, than for you to say information was confidential and you didn't want to release it. Okay? And there are other cases for that. There's the McClure case, and there's also a legislative act. What is it? We're three main batches of legislation. We know what a legislation is. So when there's a legislative act and a legislative act exception, for example, the legislation has said that although this information is confidential, you need to release it. There's some information that is required maybe by the courts or by a particular act. You can't hold that information confidential. Okay, so those are important things to note under confidentiality. Since confidentiality is one of your major duties of loyalty under the R&E, like we said, the 3 C's, it should be something that you should just note all these points. So if you're discussing it, no, don't just discuss this thing has been confidential, we don't want to release it. You need to talk about what entails confidential information. You can easily mention privilege just to show that you know the information, litigation privilege, talk about the exceptions, and then move on to how this particular scenario, for example, applies and how this is a breach of confidentiality. Okay. So that was mostly section B. We talked about parts of section C when we're talking about the lawyer as an organization or the lawyer in an organization. There's a list of things under the lawyer as an advocate. So there's a list of things, mostly bullet points. So what a lawyer should do at trial, what a lawyer should do during discoveries. If you go to discoveries and you get documentation, how much of it should you be telling the other party? If you're a prosecutor and you get information, you have to declare all this information and documents in your list of documents. It's just an obligation under the Modal Code. If these documents are now seen as confidential or privileged, it's now up to the judge to go ahead and say, okay, I want to open a request for this particular document to be released. But it's not up to you to state that I'm not releasing this information to protect my client. So let me give you an example. There was a case where there was a hospital and a patient went missing. The patient died and the body went missing for a couple of days. Okay? They did an investigation into where the body was. It took about a week and they found the body in the hospital. Now, when they put together the discoveries and the documents and they put all the information together, they just put investigation on whereabouts of the body. There was nothing as to whether there were internal memos, there was nothing as to whether there were opinions, there were no letters, there was no email trail, nothing. And they were saying that that was a breach of ethical practice in that you still have to tell us all the things you discovered. Do you understand? And everything be listed. It's then up to the court to say, fine, we know this is privileged information and we request for this. But then not saying anything and putting a simple line and saying there was an investigation is not attributable. So if you go to the Modal Code, there are things about advocating in trial, how to treat your fellow lawyers, a list of things, how to relate to your other lawyers in trial, what to do during cross-examination, how to be a great advocate. All of this boils down to the competency of the lawyer. Are you a competent lawyer? Can you carry out your activities effectively? Okay? And last but not least is partially deals with justice. And as you can see in your scenario, it talks about should there be pay? Even though a person doesn't have access to justice, who should pay? Should it be paid by the society? Should they have legal aid? Is there enough access in rural or out of reach locations? Do First Nations people have access to justice? Do people who are on the lower spectrum of the income pay? Can they pay and afford lawyers? If they can't, what has been made and provided for them to have access to this justice? What are the problems and possible solutions? What are the lawyers pro bono or firms pro bono obligations? Community clinics, constituency fees. As a paralegal, what are you expected to do? Can you act outside your required objectives? So access to justice is really short. It's not so much. It's just information. It will probably come out as a short answer question. So once you have all that information, or you've indexed properly and you know where to reach the information, you should be fine. So I've been talking for a while. I would love you guys to ask questions on anything that we've discussed, any clarifications that you have, so that it's not just me pouring out information. This is an introductory class. So I told you what basically the course is about, the information. Nothing should sound new to you because I know that you're common law practicing lawyers. So it shouldn't be new information. It's just that the Canadian aspect of it has some tiny nuances that are different, and based on the fact that some of their sources are case law and disciplinary actions, obviously they would have unique properties in their model code and ethical practices. So do we have any questions from anybody? Do you have anything you would like to clarify or something you would like me to explain better? Yeah? Estelle, I saw you on my screen most of the time. Do you have any issues? Fumilola, your hand is up. Do you want to go ahead and speak? I didn't notice that.
Thank you very much. Good afternoon, everyone.
Hi.
Would there be a replay of this class? Are we going to have access to it?
So the class, the recording is being put on our YouTube page. So it would be uploaded because our classes run over this weekend, today and tomorrow. So it would be uploaded next week, sometime next week. Are you on the WhatsApp chat group? If you are, okay. So maybe send an email to inquiries@ncaaguides.com. They'll add you to the WhatsApp group. So whenever there are updates, like there's a new video on the YouTube page, they will send out the links. Usually our Facebook group as well. We usually send out links there and we let you know so that the classes are all available for you to rewatch and go and get the information that you missed in the class itself.
All right, thank you very much.
Chichi, your hand is up.
Yes.
Hi.
Thanks a lot for your intro and
Okay.
overview. My question has to do with where you talked about sanctions.
Okay.
I wasn't so clear about the cases that you mentioned. You know, what the basis for the different sanctions that were given were.
So each case is very unique, which is why if you look through your syllabus, the syllabus has about 97 or 98 cases in professional responsibility. And people ask me if they need to read all the cases. Most of the cases are just for explanation, because if we say that case law is a source of professional responsibility, almost every case has its own unique issues that occurred. Some of them might be similar, but professional responsibility doesn't function on precedents. So they won't tell you because it happened before in another matter that we're just going to carry out the same sanction. They usually look at each particular case specifically. So the differences are that you have to actually go and read each one. The ones I listed, all of them have specific and different sanctions. Some of them are suspension, some of them are disbarment. They're just examples of like 6 or 7 different sanctions that I think you should have and list on your sanction list, if in case you get a question about sanctions for lawyers. Okay, so it's unique. It's not like there's a summary of each one. For example, for Hunter, let me talk about LSUC and Hunter. He was helping his client, I believe, with a family matter, and then he decided to have a relationship with her. Now, this raises an issue of conflict of interest, and usually you should seek consent. A lot of these cases where we see that a lawyer had a relationship with a client, sometimes they do seek consent, okay? But he didn't in this case offer her independent legal advice and say you can go ahead and seek independent legal advice, okay? But here, he reported himself to the Law Society. Okay, he resigned as treasurer. He was in a position, he resigned as treasurer of the LSUC. He submitted himself to disciplinary action. And because of that, he was granted a 60-day suspension and $2,500 cost. Okay, now this is unique to him. There's another case where another lawyer was dating a 16-year-old prostitute while he was helping her get her boyfriend out of jail. Okay, he didn't report himself. He denied culpability. He tried to deny the fact that he had done anything wrong, and he was disbarred. So there's a similarity in the cases, in fact, that there was an affair, but obviously the solutions and the things that were considered are totally different. So each case actually has to be looked at on the merits. What you're looking at is the case and the ratio. What was the sanction? What was the solution? You don't have to pull out too much information. Just say lawyer had an affair or dated 16-year-old client because of this. So you are reading the case and pulling out the information you can use. So that when you're referring to a conflict of interest issue, or you're referring to a sanction issue, you can reference the case. You don't have to go and discuss what happened in the case. The people marking already know the case. Reference the case and say, in this case, this was the sanction that was issued. Chichi, did that help? Hello?
Yes.
Okay. Okay.
Thanks a lot.
You're welcome. You're welcome. Are there any other questions? I think there's something in the chat. Okay, no, there's no talk in the chat. Any other questions? Let me see if there's anybody I want to ask a question. Bonita Mola, can you talk?
Hi.
Hi, how are you?
Hi. Thank you very much for this class.
Everybody... Oh, okay, that's Estella. Hi, Estella.
Hi. I'm from a civil law jurisdiction, so this class is almost everything you say is quite new for me. I didn't understand the concept of privilege. Could you please repeat it or just run up that concept, please?
I didn't get it. You didn't understand what part specifically?
The definition of privilege. Lawyer client.
The definition. Okay. So privilege, the discussion of privilege is under the discussion of confidentiality. And I know that you got it up onto the fact where we talked about duty of loyalty and the 3 C's, right? So you have a duty of confidentiality to your client. Now, the duty of confidentiality is that information that you have received as a lawyer, you need to keep confidential. But there are levels to this keeping of the information confidential, okay? Now, there's an issue of privilege under confidentiality. We've noted from discussions that confidential information arises as soon as the client discusses information with you, okay? So even your preliminary discussions, gathering information before you actually start to represent the client, are seen as confidential information, okay? Now, privilege is more narrow. It's inside confidentiality. So all information is seen as confidential, but privilege is a legal obligation. Confidentiality is an ethical obligation because nobody else knows what your client has discussed with you. So your client tells you, my kids, I'm having issues with my father, they're trying to take my kids away. That is all information that they've given to you in discussions that you are keeping confidential. But with privilege has to do with a particular matter that you are treating on behalf of that client. It's a legal obligation. So an example is litigation privilege. A client comes to you and says that I have been fired, okay? And as I have been fired, there's a labor issue that I think that my employer has handled, okay? And I would need you to look into it and represent me. So you would speak to that client and say, I would need you to provide me with your employment contract. I would need a list of emails and information that you have sent. I would need documents to prove that maybe you were discriminated against. Do you have any information that shows that can prove our case? And the client will provide you with this information. This isn't discussions, this isn't ancillary matters that happened. It's specific to the case at hand, okay? With privilege, your protection of that information starts at the beginning of that case or trial and ends at the termination of that case or trial. So as soon as we conclude the labor matter in court, those documents are no longer held by me under privilege. The information is I'm no longer obligated to hold that information as privileged information. If a court case or a matter comes up in the future and they require that documentation, I'm no longer obligated to say this is privileged information, I can't share it. So it's more limited, it's shorter, it's a shorter lifespan than confidentiality. But if while I'm representing you, I find out that you're having money issues, you're trying to sell land and all of that, that's confidential information that I shouldn't share with anybody because it was an ethical contract between you and me. You told me something private and I am keeping that information safe for you. Unless there are now exceptions. There's supposed to be fraud committed, there's some public policy issues, and all those things we stated earlier. That's when that's the only time I can release that confidential information. Okay? So note it as you're going through your notes, when you have the textbooks or you go through your notes, you would notice they gloss over privilege, but it's good for you to know and note. Because if you're reading a scenario, and they mention in the scenario that so the information was passed across to you, but it was for a particular matter, you already know that that is legal obligation, that is privilege, not confidential. So you have to know whether it's terminated at the end of that case or matter or not, or whether it's a lifetime, the protection of that information consists or continues indefinitely. Estella, is that better? Fantastic. Perfect. Perfect. I will lower your hand now. So this is just apologies. This is just the introductory class for professional responsibility. We have a 4-week intensive class, the NCA Guides. It will run from the 5th of December for the 3 weeks following that, the 5th and the week after that and the week after that in December. We'll go on a break for the new year, and then we'll have a final class in January because the exams are February 8th. And I believe January 23rd, we will hold an exam preparation class. So once the intensive classes are over, we will have an exam preparation class. Members of our intensive class would get free access to the exam prep class. If you're not part of the intensive class, you can register for the exam preparation. So you finished reading, you've gotten all the information, you then now want an NCA structure on how to answer questions. You can join our exam preparation classes for that structure. We'll treat questions, how to answer it, how to save time. The NCA Guides has an NCA Canadian Professional Responsibility Index, like I explained. Our index breaks down, I can actually show you, I think, since we have a bit of time. Once I finish talking, I'll try and show you the index and explain the uses of the index to you. It's for sale on the site. If you join the intensive classes, you do get a discount, and I think get it for half the price to help you with your studies and help you with saving time for the examinations. Apart from that, you can access this video on YouTube, like I said earlier, sometime next week. Okay, so yes, this is on the website. We do have courses available. We have a framework for admin law. We have the professional responsibility index. The index, basically, if you look at your model code itself, it has an index, but the index is giving you topics that are discussed in the model code, not the rules. So the way we've structured our professional responsibility index is in 2 parts. The first 9 pages actually pulls out all the rules in the model code into 1 line in that first part. So if you're in the exam and you're looking for rule 3.4.1, if you go to your model code, you would have to flip to rule 3.4.1 to get the rule out. But with the index, our index, you would be able to scan and pull out what 3.4.1 is saying, 3.4.2, what 7.4.4 is saying, and we pulled out the important commentaries that you should note and mention in your exams. Then the second part goes up and breaks it up. It has more information. It has things like cases that are referring to that particular aspect. So if you open rule 3.4.1, for example, in our annotated index, you would see 3.4.1 conflict of interest. You would also see things like cases that must be mentioned, what each line of each case says, information and notes that you must add to your exams, like points that I noted, such as like the bright line rule, substantive risk rule, so that you don't have to start going into your notes or opening the model code itself. All the information is in one place. Okay, so that helps you with saving time because you've read, you have the information, you might just have missed something. But by looking at that, that gives you the pointers and you just migrate that information into your typed exam sheet since we're typing in the NCA exams at the moment. So are there any other questions? No? Yes? So I'd like to thank all of you for attending this. I hope the introductory class was helpful. I hope it's going to direct you in how you should read and the information you should look for. I would look forward to having you in my class, intensive classes, where we can actually sit down and discuss these cases intricately, understand what the ratio is, understand what the NCA is actually looking for, and the information that you need, and then do the exam prep course so that you're prepared for the examination. I know most of you need to join other classes that we're having today, but I'm very grateful that you came. And if there are no other questions, we can end this class. Okay?
Okay,
thank you very
much.
You're very welcome.
Thank you. All right, thanks, Funta.
You're welcome.